welcome everyone. In this last session, we're going to have Vietnam and Cambodia speak to us about what's happening in their region. Uh, um, and I'm going to hand over. Uh, we're going to hand over to Hung from Vietnam first, and then Vanak from Cambodia will speak, and then after that we will go around the region. I think we start with Singapore, followed by Korea, Indonesia. Yes, in this order. So over to you, Hong.
Hello, everyone. Okay, let me share my presentation. Hello, everyone. My name is Hùng Phan. I'm Senior Associate at RHTLaw Vietnam. Today, I will share with you about liquidated damages in theory and in practice in Vietnam. My presentations including 5 sections. The first one is about the general information about liquidated damages in Vietnam. The second one is about advantage and disadvantage of liquidated damage. The third one is about provisions that are similar to liquidated damages under the laws of Vietnam. The fourth one is about the alternative approach to the liquidated damages clause. The fifth one is about liquidated damages clause in litigation practice in Vietnam. And the sixth one is a key takeaway, and the final section is Q&A. So let's move to the first part about the general information about liquidated damages. As you can see, liquidated damages agreements are very common in commercial contracts, especially considering the natures of the contract. It will be difficult for the aggrieved party to prove actual and direct damages. So the party in case the party wants to avoid lengthy dispute proceedings, or the party desire to distribute it in a numbers of specific events, so they can use liquidated damages. The above agreements are used in share purchase and sale contracts, loan contracts, and especially construction contract to deal with the breach specifically agreed upon in both types of contracts to distribute risk according to the commercial intention between the party. And liquidated damages are usually spread through one or more formula with the pre-agreed variable in order to have the party have a mechanism for determining damages easily and save time. So in construction, liquidated damages are also customary in construction contracts, and in fixed contract form, usually including 2 clauses of the nature, such as compensation for liquidated damage and compensation for delays in progress and compensation for quality violations. In Vietnam, the fixed contracts form has also encouraged by the Ministries of Construction of Vietnam to apply for the projects funded by the state investment capital. So what these terms have in common is that they are not based on the actual damages that occur at the time of breach of obligation by one of the party, but have been estimated by the party in advance at the time of entering into the contract. So in particular, for violations caused by the construction constructor delay, the constructor must pay the investor a fixed amount per day multiplied by the number of days behind the schedule. So for liquidated damages, there are some advantages and some disadvantages, as you can see on my slide. The first one I would like to share is about the advantage of the liquidated damage. So when the party breaks the contract, in many cases, it's very difficult for an aggrieved party to prove to their losses that they suffer, especially for the reductions in revenue, profit, or something else. So, but for the breach damage, such as intangible assets, such as intellectual property rights, goodwill, reputation, trade secret. So, and they will take a lot of time and effort to prove for such losses and gathering evidence for the loss So as a result, in commercial contracts, especially the construction contract, the party usually agree upon the liquidated damages at a fixed amount at a specific percentage of the contract value. So it will be easy for them when one party break the contract, they can use that clause to ask for compensation. However, we think that the liquidated damages clause also have some disadvantages. There are two disadvantages as I can share with you is that the first one is unfair bargaining and illegal profiteering. For example, when a strong party they have more power than the weak party, so they can use their position to ask and to negotiate with the other party in the contract to ask for higher percent in terms of liquidated damage. And the second one is that is circumventing the regulations on contract penalty. Next, I will share with you about the provision that's similar to liquidated damage in Vietnam, because actually liquidated damages is not recognized under the laws of Vietnam. So under the laws of Vietnam, there are two provisions that may be similar to the liquidated damage. The first one is compensation, and the second one is penalty. But it also have a different approach under the laws of Vietnam. Under the civil code, it's recognized 5 types of material damages. The first one is property loss. The second one is reasonable cost to prevent, limit, and remedy the damage. The third one is loss and reduce real income. The fourth one is benefits that would have been earned by the contracts, and the last one is all the costs incurred by the failures to fulfill the contract's obligation that do not overlap with the benefit that would have been enjoyed by the contract. So and under that is about compensation, but in terms of the penalties, under the civil code, there are no ceilings or no limit for the penalty. But in the other hand, in the laws on commerce, they just specifically recognize 2 types of material breach. The first one is actual identifiable physical loss, and the second one is direct benefit that the aggrieved party would have enjoyed if there were no violations. And in terms of the penalties, under the laws on commerce, the ceiling for penalties is 8% of the breach values of the contract. So there are different approach under the laws of Vietnam in terms of the civil code and the laws on commerce. So it's difficult to explain the reason why there's a difference between the civil codes and the laws on commerce. As you can see, the civil codes allow the party to agree on the unlimited amounts of compensation for damage. But the commercial laws set a ceiling for compensation and penalties in case of violation. Maybe it's the time for the National Assemblies of Vietnam to consider amend the laws on commerce, because it were promulgated in 2005, so it's more than 18 years. And the National Assembly, they can consider refer to the approach of other legal systems of some different developed countries in the world. For example, as you can see on my screen, on my presentation, for example, in the Article 2718 of the United States Uniform Commercial Code, the estimated damage settlement may be admissible if the amounts of compensation agreed upon by the party is reasonable close to actual damage. and it's difficult to prove the loss or the application of other remedies inconvenient or impractical in practice, and a liquidated damage law with high but unrealistic compensation amount will be regarded as a penalty and become invalid. So next, I will share with you about the practice of liquidated damage. Basically, in general, the in some arbitration centers, there are some arbitrator, they agree to apply, they are allowed to apply liquidated damage, but in the court do not recognize the validities of liquidated damages. So in this case, this is the case that we support our clients at the Vietnam International Arbitration Center. So this slide is about the summaries of the case. So MC Storage project is located in Song Thần, in the two industrial parks in Bình Dương province, invested by MVC Company Limited, and TD companies were appointed as the main construction contractors, and AC Company Limited were appointed as the project manager. So TD engaged ALS Construction Company as a subcontractor for the main item of the project by the contract agreement in January 2017, with the total values of the contracts is more than 50 billion Vietnam dong. And under the contract between ASL and TD, the days of completion of the whole work is 240 days from the days on which the project manager notified ALS of the commencement of the work. As of the days for completion, ALS must satisfy 3 conditions as required in the contract. However, as of the days of the counterclaim, the taking over certificate had not, and you can see there are 3 conditions. The first one is that AOS must complete in the executions of the whole work. The second one is passing the test on completion of the works, and the last one is submitting to TD the proper as-built drawing. So as of the days of TD counterclaim, the taking over certificate had not been issued since ALS had not completing remedies, pending defects, and other pending items mentioned. Therefore, TD requests to determine and temporarily calculate the delays in satisfying the completion condition from the updated days for completion, which is 10th January 2018 until 24 September 2019, with a total days of 622 days. So based on the contract, TD's claimed for the compensation of 622 days, multiply 15 million per day. So the total amount is 9.33 billion Vietnam dong. However, under the contract, the party agreed that the limit of liquidated damage is 10% of the contract value. So, as I said before, the total values of the contracts is more than 50 billion Vietnam dong. So the total amounts of liquidated damage that TD can claim ALS is more than 5 billion Vietnam dong. So the arbitral tribunal consider that the agreement between the parties on liquidated damages is not contrary to any provision or is prohibited under by any provision of the laws of Vietnam. Therefore, the arbitral tribunal, they recognize this clause. So, but the arbitral So in conclusion, the arbitral tribunal, they accept a part of TD claim. So they calculate based on the years, and they accept the claims of TDs with the total amounts of more than 2 billion. So in conclusion, you can see that although the arbitral tribunal, they just accept a half of TD claim, but we can see that the arbitral tribunal in Vietnam International Arbitration Center, they recognize the validities of the liquidated damages clause in the contracts between the party. However, the courts in Vietnam, in contrary, they do not recognize the validity of the liquidated damages clause in the contracts. There are two specific cases that the Supreme Court of Vietnam, they refuse to recognize the validities of liquidated damage clause in the contracts. And you can see there are the decisions on cassation reviews number 15th in September 2016 of the Supreme Court between technical and service judge stock company A and company B. So according to the contract signed between the party, company A shall provide the 3 billion package for the project invested by company H. Company B was the main contractor. The contractor values were about 5.1 million USD. The expected completion days of the project were in May 2008. In case of failures of the completion days, company A must pay the investor with the losses caused by the error, which is equivalent to 5% of the contract value. So, so please remember the contracts, they agree that the compensation here, no, the penalty here is 5% of the contract value. So in reality, company A complete the project 288 days behind the schedule, and company B's make payment late, and it was not in the lines with the agreement under the contract. So company A has required company B to pay for the outstanding amounts, and company B argued that company A has violated the construction schedule, so it should be liable for the compensation amount equivalent to 5% of the contract values. This amount would be offset against the payment obligations of company B. So at the first instance court, the court declined the claim of company A and forcing company B to pay the outstanding amount, but the appellate court decided to uphold the first instance court judgment, and company A submitted an application to revoke the decision. That's the appellate court according to the cassation procedure. So the cassation decision made by the Supreme Court of Vietnam, they said that the liquidated damages clause applied for the violation on schedule shall be recognized as penalty clause under the laws of Vietnam. So you can see here the Supreme Court of Vietnam do not consider liquidated damages as a separate agreements between the party, and they believe they think that it shall be treated as penalty clause under the Vietnamese law. And according to the agreements, according to the commercial laws, specifically it is Article 201 of the commercial law. As I said before, the ceilings for penalties is 8% of the values of the breach contractual obligations. However, the penalty that the party agrees in the contract is 5% of the entire contract value. So the Supreme Court, they refute and they apply the Article 201 of the commercial law, and they just recognize 8% the penalties 8% of the values of the breaching contract. The second decision by the court is the appeal decision on appeal against cassation number 11 in June 2020 of the Supreme Court. It's a dispute between InSouth Saigon companies and InSouth Just Stock companies. So this decision has not been disclosed fully, so I just have a summary of the decision of the Supreme Court here. So according to the decision of the appeal against the cassation, the Supreme Court identified that Just Stock company must compensate for InSouth Saigon companies based on the compensation rate set forth in the contract according to the judgment of the cost of first instance, and the cassation decision was not appropriate, and compensation damage must be calculated based on the actual direct loss in accordance with the provisions of the commercial law. So here, the court required the aggrieved party to calculate their loss and prove their loss, and the court they refused to recognize the liquidated damages law that the party agrees in advance. So in conclusion, there are two things, two key takeaways. The first one, we can say that despite the fact that the arbitral awards may be set aside by the court, however, in case the party wants to apply the liquidated damages clause in their agreement, we suggest that the parties should choose arbitration at a dispute settlement party, so that there would be a chance that the arbitration center, they will recognize the liquidated damages clause. And the second one, that's in case the party wants to follow the ceilings of the legitimate penalty according to the laws on commerce, which is 8% of the violated value. The court is the only way for the party to at the dispute settlement party for the party. And that's at the end of my presentations, and I would need to wait. I wait for the sharings of the others, country members about the application of liquidated damages after the presentations of my colleagues in Cambodia. Thank you.
Right. Thank you, Huong. Just 4 points that I wanted to just keep, and we'll come back to it when we do the Q&A. One is that you have the Civil Code 2015 versus the Commercial Code, Commerce Law 2005, and where you are. Two, the fact that you talked about penalty, and you know, it's I think that's somewhat international. Three is the you know, when you refer to case law, maybe you could just tell us how is it that you find your case laws. You see, like in Singapore, we have a database where you can actually find your case law easily. But I'll leave this to later, and I'd like to pass it on to Vanak to deal with case updates from Cambodia. Thank you.
Okay. So thank you, Huang, for your presentation on the liquidated damages in Vietnam. Let we move on to the Cambodian presentation. Well, our presentation will be mainly on the legal updates of regulatory frameworks in Cambodia relating to construction. Well, before I begin, I think I see some Cambodian names in the list of the attendees. So hopefully we get some questions from the audience today. And welcome to our webinar today, Cambodian section. My presentation will be hovering on the cases of the construction certified, which so we count 2 cases, which is one in Sihanouk, relating to a building collapse. And the second case is the same incident, which in another province. And then a brief overview of the general development of a construction framework. And then we move to the construction certifier application, which will cover by my associate Vishal. He will be presenting how the what are the requirements to apply for the licenses, and what types of licenses and other basic requirement and procedures are to acquire those licenses. In 2019, there was a tragic incident took place in one of the Cambodia coastal towns in Sihanoukville. So a 7-story building collapsed due to technical failure. Of course, you see the bracket there's we mentioned that the construction was carried out without any approval from the authority, and how would that be possible? I mean, the audience and the attendee today would want to know, but just to let you know that since 2017, the influx of Chinese investment in property development was so huge, and there was many construction projects going on throughout the country, especially in Sihanoukville. So ministry were not able to cope with the numbers of new projects being built. They oversee. They were not able to oversee the construction project properly. So some of the construction were carried out without any permit at all. So this incident actually took place, and they were resolved. 28 workers were killed in total, 26 were injured. And the building projects belong to the Chinese developer. And the offense took place, and they were resolved in these all charges: manslaughter, unintentional injuries, and intentional cause damage with aggravated circumstances, which is under Cambodia Criminal Code. So the court, this case was brought to the court by the our Prime Minister lawyer, voluntary lawyer group, and the court decided that the project owner was found guilty of these crimes, and the court was heard throughout the 3 courts, the local court and to the Supreme Court right now. These are all the defendants who were held responsible. So the Chinese national building owner was found guilty of 3 offenses, was sentenced to 3 years in prison, and the building contractor were also found guilty, 3 years each, paying compensation, which is were decided at the appeal court. Even contractor were also found guilty, and both were joined for civil compensation, were ordered to pay 5,000 each to the injured person, and up to 20K for each deceased victim. So this case was actually now decided within the court, and the victim were paid, and the money were compensated to the victim families, and the case was now heard at the Supreme Court. So case number 2, the same incident. There was another collapse in Cap, one of the province, just the following year, which is in 2020. So the same. The cost was not that the building was not built according to the technical standard, and in result, 36 workers were killed. So you can see on the right there, the picture of the building was purely constructed. This was the picture when it was under the construction, and then the collapse after the incident. Again, building owner were arrested, accused of manslaughter causing unintentional injury. but this case is an ongoing case, so there was no verdict yet. So this case was represented by the Prime Minister lawyer group as well. And we all waiting for the result now, whether the court would decide and find those building project owner and construction owner held liable for these incidents. So with these two incidents, there was concerns on the sustainability of a construction project in Cambodia. So then the PM, Prime Minister, issued a direct order to the Ministry of Land to draft new laws, especially the construction laws and construction certifier, which will be discussed by Vishal. So in these slides, I will give you a brief overviews of how law related to construction and infrastructure, land properties in Cambodia evolved. So if you look back into Cambodia's in Cambodia histories, in the 1990s to 1970s to 1990s, Cambodia went through what we call a dark era. So basically, everything started in 1993 when Cambodia first got our first elections. So we can all say that 1993 is the rebirth of Cambodian legal system. So back we started to develop our own law, starting from the constitution in 1993 until now. So it's roughly like 30 years of the new legal system. So I can say that we're quite a bit young compared to our neighboring countries, especially of course to Singapore. So the main law relating to the construction and real properties was the land law, which was enacted in 1997. So this law basically covered everything, all matters related to construction, immovable properties, and developments of properties. So the gaps for the main developments of the land laws is from 1997 to 2019. So there were many other regulations was enacted by the government to regulate the construction industries and properties. The main focus today on this presentation is actually the construction laws and the 2020 sub-decree 225, which give specific requirements for application to the construction certifier on how to apply for it, what are the requirements for a construction company to get the license in order to carry out the certifying of a construction project before giving out the permit. So the law was actually passed in December 2020, right in the mid of the outbreak of the COVID-19. So back then there was no progress at all. It was just a law which no implementation at all. So then later on in Jan 2021, broadcast and subsequent guidelines were also put in place to support the implementation of the sub-degree and how the requirements and the application process, the procedures on how to get it were listed down in this guideline and broadcast. And I think Vishal will basically covers on the requirement of such and what types of construction certifiers. And just give you guys a hint, since the enactment of the sub-degree construction certifier, the Land Ministry reserved the option for the application to any developed country who have experience in constructions to apply for that. I mean, any companies or any entity who has more projects, carry out many projects or certify many construction project consultation in their foreign countries, they are more eligible to apply for than the local companies. As we speak, our firms is actually assisting one Singaporean client, Singaporean companies to apply for the construction certifier, and we are in the midst of submitting the application to the ministry as well. So I think Wisal, can you carry on the procedure? I will stop sharing.
Yes, thank you.
So thank you.
So I start sharing my screen here, and so good afternoon, everyone. I'm glad to be here, and I'll cover the last part of today's presentation on the construction certified license in Cambodia. And just a bit of its origin, Mr. Van has covered most already that the cause of the accident we mentioned in our presentation mostly come from the non-compliance of technical standard in the construction. And so one of the solutions that the government attempt to solve this problem is the privatizing of the construction certification service through the offering of the construction certified license. It started the implementation from 2021. So in this presentation, I will tell you what is the construction certified license and why is it important, and how is to get this license. What is this construction certified license? So basically, it is the license that allows the certifiers, which can be a company or the professional, to inspect, analyze, and certify the design document, which may include the architectural design or the structural designs, as well as the calculation and technical inspection or technical standard for any constructions. So this is made to ensure that those constructions are in compliance with the technical standard and regulation that is issued by the government of Cambodia. And after they inspect, analyze, and certify this document, the certifier will need to issue the report on the construction inspection and certification, as well as the certificate of compliance. And here's why it is so important. Here's why this license is so important, is that the report on construction inspection and certification, as well as the certificate of compliance that is issued by the certifier, are the main documents for any construction that require permits from the competent authority, which can be the Ministry of Urbanization and Construction. And so when the builders or the construction companies applies for the construction permit or the construction site opening permit, the ministry or other competent authority will ask the applicant to submit two main documents. The first one is the report on construction inspection and certification, as well as the certificate of compliance that I just mentioned. And the actor that issued this report and the certificate of compliance is the holder of the construction certified license, which is why the holder of this license is quite an important actor in construction sector in Cambodia. But the scope of those license holder is different based on the types of license they hold. So based on the law, there are two types. The first one is for company, and the second one is for the professional. And the biggest license for the construction certifier is the license for construction certifier of general construction for level 1. So this is the biggest one, and it covers all what others license can do. So there are construction for architecture license, construction structure license, the construction mechanics, electricity, or water license. Those licenses act separately in their own parts, but for the general construction level 1, they are the one that can do all others license holder can. So based on the last report from the Ministry of Land Management, Urban Planning, and the Construction, there are currently only 5 companies that has obtained this construction certified license. And the most common type is the biggest one, which is the construction certified license for general construction level 1, which is also the focus of today's presentation. And this is the sample for the license. So moving on to the requirements on how to get this license for the investor or for any professional who attempted to get a hand on this license. And on today's presentation, we focus on the license for general construction level 1. And of course, there are some main requirements that the investor need to consider before they start the activities in getting this license. So the first one is the requirement for registered capital. The capital cannot be lower than 1 billion real, or around $250,000 US dollars. And the second one is the insurance requirement or the deposit requirements that is made with the National Bank of Cambodia. So the deposit requirement is around 125,000 US dollars for this case. And the third and also important one is the requirement for human resources. So the company that intends to get this license must have a technical director who is a civil engineer with at least 20 years of experience. And they need to have 3 technicians as the license architects and 5 technicians as the license engineer with at least 15 years of experience. And of course, there are some detailed requirements on the professional experience. They will require those technicians as well as the license architects or the license engineers to show that what type of projects they have involved before for this case. So those are the main requirements that the investor need to consider before they attempt to start the activities to get this license. And after those requirements are considered, they can start the procedures to get the license. And here I will just go briefly on the administrative procedures that the investor should know. So there will be checklist on the required documents regarding the license, and the applicant can submit those documents to one window service office. And after that, the one window service office will check on the formalities and pass on those documents to the General Department of Construction. And the General Department will review the application, especially on the qualification of the company. And if nothing is wrong, they will pass these applications to the authorized principal in the ministry. And the authorized principal will review and make the final decision on the application, whether the license can be issued or not. And if everything is done, they will pass the license to the one window service, and the applicant can get this license. So based on the law, if everything is perfect, it can be around 1 month, but in practice there could be more for this case. And I believe this is the brief for our update on the construction certifier, and we happy to get the question from our audience. Thank you.
Right. Thank you so much. Very interesting. I like the fact that we will come back to that in a while, but the fact that you have a clear structure in place and then licensing provision. So I thought it's very, very interesting. Now, thank you so much for Vietnam and Cambodia doing what you've done. We are about 10 minutes away to the end, so I'm going to ask and request that if possible, we have a little bit more time extra after we have Singapore, Korea, and Indonesia talk about the 2 aspects, what Hung had covered and what Vanak and Vishal had discussed. After each of these countries tell us our viewpoint on what we have in our respective countries, let's see if there are time for question and answers as well. So with that, we start with Shafiq first, who's going to do the LD part, right, from Singapore.
Hi everyone. Okay, thanks for the presentation earlier. So I'm going to share about LD, about liquidated damages in Singapore. So I think in Singapore, in most construction, it's quite common to see liquidated damages clauses in construction contracts as well. So in such construction contracts, usually they specify the amount of damages that the contract will have to pay in the event of a delay in the completion of the project. So I think the main difference here is that in Singapore, usually the law on liquidated damages is covered by common law. And we don't have any statute or codes that address this point. And under common law, when we talk about liquidated damages, the two main issues usually arise. And first one is the rule against penalties. And the second one is the prevention principle. So I'll just briefly talk about these 2 points. So rules against penalties. So I think if you see in most common law courts, whether in Singapore or the UK or elsewhere, usually liquidated damages clause are attacked for being unenforceable due to them being penalties. So what do I mean there when we say that these LD clauses amount to penalties? So I think in the Singapore courts, the recent Court of Appeal decision actually clarified this point. Actually, they reaffirmed the test that has been applied for all this while. They adopted the test from the English case of Dunlop Pneumatic Type Company Limited. This is a 1915 English case where essentially what they do is they look at the amount of the liquidated damages payable, and they also consider the greatest conceivable loss that could flow from the breach. And in the event the amount of LD payable is more than what is the greatest conceivable loss, then the clause may be considered a penalty. And if the clause is considered a penalty by the courts, then it will not be unenforceable. So essentially what it means is that the LD clause must represent a genuine pre-estimate of loss of damage for it to be upheld. Also, the other point about the prevention principle is this: while parties may have LD liquidated damages clause in the contract, another ground to argue that the liquidated damages clause is unenforceable is to say that the employer's act of prevention had caused the delay. What this means is that, let's say the employer entered into a contract with a contractor, and the delay, usually the contract would have a start date and a completion date, and any delay was actually caused by the employer. So in this case, we say that the employer's act of prevention had caused the delay, such that the employee could no longer insist on the contractually stipulated date for completion. In such a case, what do we call? We will call that the time for completion will be set at large, and therefore the employer can no longer rely on the liquidated damages clause. So that's why in such situations, when we have a liquidated damages clause in Singapore, it's also important to have an extension of time provision, because that extension of time actually protects the employer's rights to actually enforce on the liquidated damages. That means if the employer actually manages to issues an extension of time, then the liquidated damages clause would still be enforceable in Singapore. Yeah, that's all. Thanks.
Thank you, Shafiq. Thank you so much. Okay, so I'm just going to quickly deal with Cambodia's point about building collapse and certifier. So in Singapore, what we have is we have the Building Control Act, and Section 23 of the Building Control Act deals with building collapse, and Part 5 of the Building Control Act deals with certifiers, right? But on the builder's licensing, I'll just make a couple of quick points as well. So coming back to this, the building collapse, right? Section 26 allows the Commissioner of the Building Control to intervene and take the necessary actions if construction activities are deemed to pose risk to people, property, or the construction integrity of a building and the surrounding area. So very clearly, it sets out the details for that. So, in a set of slides that we will send out and share, the more details of this is set out there, and then the penalties that are imposed are also set out there. Right now, there was a recent case of a building collapse on the 15th of June this year. There was reinforced concrete walls that had collapsed, and a 20-year-old Indian national had died. Right. The preliminary report says that the chief executive of the construction and engineering company and his counterpart will have to personally account to the Ministry of Manpower for the building collapse. Now, account means that probably there'll be an investigation and then a follow through with it. But what exactly happens is to be seen, right? So that's about building collapse. Now, on certifiers, remember I mentioned part 5 of the thing. It provides it encompasses different sections that deals with builder's license, restrictions on unlicensed building, applying for builder's license, requirement for license, and so on. Right, and if you look at the Building and Construction Authority, they have a code or guidelines on how building licenses are to apply and who it should apply to. So again, on the slide deck that I would send through, it's hyperlinked and you can take a look at it at your own time on that. Now, one last quick point was there was a question about a case involving a certifier, right? And then issues came out about whether or not the certifier, who was an architect in that particular case, had issued a late interim certificates, issued several certificates allowing greater amount to be paid, failing to issue a certificate for one or more of the total amounts, and all those kind of things. And essentially the court held in that case that you cannot have the owner held responsible for what the certifier has done or has not done. And the reason for that is that the certifier is an independent person and should be allowed to carry out independent tasks. And so the owner cannot be held responsible. And likewise, the owner cannot oversee the certifier, and also the owner cannot then be held responsible, and parties cannot go after the owner and say your certifier was wrong and it's your fault. All right.
Oh,
So
wow.
essentially, this is what we have in Singapore. Thank you for that. Now I'm going to just ask next Korea to talk about what Vietnam and Cambodia has discussed. Over to Jason, would that be right?
Yep. For the Korean perspective, I'm going to speak on the liquidated damages, and I'll pass the mic over to Timothy, and he'll be speaking on the Cambodian part. For the liquidated damages, one peculiar thing about the Korean law is that we do have a statutory ground for liquidated damages. The Civil Act, Article 398, it expressly provides for the liquidated damages, and it stipulates that the parties can actually determine in advance the amount of damages payable in case there's a breach of an obligation. However, one thing that's somewhat stands out here is that there's also an explicit provision that empowers the court to step in and actually actively decide on the issue of whether the amount of predetermined damages is excessive or not. In the statutory language, it actually mentioned, it says, where the amount of damages determined in advance is unduly excessive, the court may reduce the amount to a more reasonable and appropriate sum. That's in the statutory provision. I think this is probably the key difference between the Korean court and for example, English court. Korea, that it's a civil law jurisdiction, but English law and other common law jurisdiction, if you make a comparison, I understand the rule of law is basically the penalty law, a penalty rule. The liquidated damages clause will only be upheld if the party can prove that it is like a penalty. It is so out of proportion. I know there's a huge amount of case law on this in English law, but generally I understand under English law, the practice is that in practice it's very difficult to prove that liquidated damages to be a penalty. So the court generally does not like to intervene to make the decision on its own whether the amount should be regarded as a penalty or not. But the case, this is not the case in Korea. Like I said, there's a express provision in the statute granting the power to the court. So and in practice, the Korean courts actually they often do exercise this authority quite actively to reduce to the amount of liquidated damages. That's the point on the liquidated damages. And I'll now pass the mic over to Tim.
Thank you. Just one quick point, Tim. Let me just let everyone know that we are just about to finish. So we are going to ask for about 10 more minutes for all of us to highlight the points and then take Q&A. Thank you so much.
Thank you, Jay. Thank you, Anil. I'll be really quick. So I will just cover the section that we did from the Cambodia side in terms of the license requirements from a Korean law perspective, and I think that's quite standard across most jurisdictions that there are licenses requirements. So basically, from the operation of construction business in Korea, any company that intends to operate a business has to register with MOLIT. So MOLIT is the Ministry of Land, Infrastructure and Transport, and you'd register according to your work and the prescribed requirements regarding the technical capacity, your capital amount, your equipment and facilities, etc. Pretty much the same requirements are required of foreign companies, but there are a couple of additional requirements for non-Koreans. So if you're a person, a natural person, you'd obviously have to be eligible for working visa. And again, your assets have to meet a certain threshold in terms of capital figure. Likewise, for companies, you have to establish and register your office in Korea. That's essential. The capital of the company's principal office must also exceed a certain threshold. I think that's around, speak on a correction, about 250,000 USD. And again, with respect to the technical capacity, foreign companies' experience outside of Korea can be considered by the ministry as well. If you're operating as an architect, a foreign certified architect can only perform or carry out the designated construction supervision service if the services are rendered jointly with a Korean architect, so an office registered in Seoul. Obviously, a foreign architect, if they want to practice by themselves in Korea, have to then obtain a Korean architect license. So, that would be quite difficult in terms of language ability and so on. So in essence, that's just a very brief overview of licenses, and generally the Building Act of Korea would be relevant in terms of looking at what type of licenses would be required. Again, one issue maybe just on completion of construction, if the employer of that building seeks to use the building after construction, you have to submit a supervision completion report, which is prepared by the construction supervisor, and construction completion report, which gets filed with the local authority. And again, you have to obtain a permit for use. So if there are any changes or amendments to the design, etc., again, that will require a new reporting duty and confirmation from the local authority.
Thank you so much. So you're starting. Well, I'll make some concluding remarks later after we finish with Eddie.
Yeah. Hi. Thank you, Anil. So I think similar to Korea, in Indonesia, we do have a provision under our civil code on LD. The provision is only says that if the parties has agreed on a certain amount of damages in case of default, then that amount has to be that amount has to be paid by the defaulting party, right? We don't have that much of an issue on whether or not this damages constitute as a penalty because of the excessive amount, or whether but as long as the parties has agreed on a certain amount, then that is that LD amount will bind the parties to the agreement. We do have I think also similar to Korea, the court has, if the party can ask the court to determine on whether or not the amount of LD is excessive, because in Indonesia, as I think I've mentioned a couple of weeks ago, the court has if asked by the parties, the court have the authority to make a ICO bono decision for equity. So if the court decides that this the amount of LD agreed by the party is excessive or too high, then the court may determine a lower LD amount. I think that's an LD. On the construction license and certification, I think we do have a similar system with Cambodia and sorry, with the other jurisdiction as well, because I think it's just a matter of different names and different categories. I understand that there you have a grade 1 or grade 2, but here in Indonesia we call it as a large scale, mid scale, and small scale. For investment company can only have a large scale licenses with different with of course higher requirements in terms of net asset, in terms of experts that it has, and also experience wise. But I think the purpose of the certification is to for example, for complex construction works or works that is high value, can only be done by construction companies that have a large scale construction licenses. So if, for example, if I have a mid scale construction license, I would not be able to participate in the construction of a building, of a high-rise building or so on. So the type of license you get kind of classifies the work that you can do based on your capacity and your financial capacity, and also the experience. I think that's from me.
Right. So thank you so much for that. We now just have another 5 minutes or so. I was just wondering whether or not there are any questions that any of you have, or whether any of the participants who are attending have any questions that they can then put into the Q&A chat box, right? Either the chat box or the Q&A box. But I mentioned a couple of quick things in the 4 minutes or so that we have. For Vietnam, I thought what was interesting, the question I asked was about whether your case law and the arbitration matters. How do you have access to that? How do you find those cases?
Actually, from Vietnam, in terms of the awards issued by the arbitration standards, actually the case were the case we support and assist our clients in the past, but the awards is not open for public. It just we just have a portal to accept the decision or judgment issued by the court, and it's were encrypted.
Okay.
Yeah. So so you can go to the portal of the court to find any judgment that you want to find. But for the arbitration award, there no source to extract such award.
Okay.
Yeah.
One more quick question. You mentioned that the commerce law is 2005.
Yeah.
Right? And you're wondering whether or not there will be consideration to see whether or not that will be changed. Are there talks about it, or is there an interest to try and see that happen?
Basically, now I haven't seen any late progress about they will pass a new laws on commerce.
All right, not
Maybe
at the moment,
in the
right?
future. Yeah.
Okay. All right.
Yeah.
So I mean, it's something to think about if ever they do get back to you, and then or if ever you do hear about it wanting to be changed, maybe you as a firm, you could put out some pointers on your observations on that. So that might be interesting. Over to Cambodia, you mentioned the point about that. It was not until 1993 that you started having your laws all in place, and you mentioned something about sustainability of the construction projects, right?
Yeah.
So are you saying that there is therefore a real keen interest in putting a proper framework. And it seems to suggest that, because when you talk about your license and all of those things, those kind of things highlight the fact that people are really keen on getting, or the country as a whole is very keen on putting construction in the forefront of in laws and regulations and all that. Is that what you see?
Yeah, you're right, Anil. Well, during the past few years, the Cambodian construction industry will boom with the influx of Chinese investments. And like I said, the ministry cannot cope with the growing numbers of construction projects and so on. So then, with the lacks of comprehensive laws as well, there were no proper regulation to regulate those projects as well. So with from there on, then there's a question what I just mentioned, that the sustainability of construction projects in Cambodia, whether it will be still on the grow, and whether will be their safety for construction sites for the workers as well. So our government has made a huge move to actually, the Prime Minister himself instruct the Ministry of Land to sit down with all the experts and prepare the new laws, which we will strengthen or give more security, safety to the construction workers, and as well as the construction project owner and contractor builders. So I think even I myself is also a members of the Council of Jurists. We draft law, we review laws, and we have foreseen there's a proposed more subsequent guideline and directives from the government and ministries relating to construction industries and in properties as well.
Right. Thank you. I noticed that we don't have any questions in the chat or the Q&A box. So what I'd like to do is this. I know I'm putting you all on a spot here, but I'd like each of you to give us a concluding remark on what you think about the series that we've just done, this mid-year review. While our attendance may not have been great, what we've put together as a team, I like each of you, and could I start with Eddie first? Your views on the whole series.
Yeah, thank you. So I think it has been interesting to see how it is in the other jurisdiction, and I understand that only Singapore here is the common law, the jurisdiction with the common law system. But even I think even when we compare common law system with the civil law system, such as the other for the other jurisdiction, we do have quite a similar provisions or standards or requirements. Maybe in terms of implementation, it's a bit different, because in the common law system, the implementation is very much influenced by the interpretation of the court. While I think for the civil law, it's much more of a codified approach. Yeah. So I think it has been quite interesting to see and to discuss about the application. For example, the LD, how Indonesia and Korea has a very similar provision, and also how we see that the construction licensing is very similar across the board.
Thank you.
I think that's yeah. I'll hand over to you,
Jason.
Yeah, well, basically the same thing. It's same thing here. With Singapore just being in a common law jurisdiction, and the rest of the other countries all civil law based. But we know basically they all come to the same result eventually. The common sense is what governs law in all jurisdiction, and it's interesting to see how little minute differences here and there, but then I think the overriding principle is the same, and it's been very interesting to see that through the presentations that have been held in different countries.
Thank you,
Yes.
Timothy.
Hi, Neil. So first, I think it's a great project to put together to get us all together on the same page and covering the same topics. I think from a personal perspective, it's good from our side, in that we need to to prepare for the presentations, to go and relook at all new case laws, etc. So, for example, when we covered the serious accident, case law, those are new to us as well. So, it's an opportunity to also develop our own practice, which means we're more on the sort of cutting edge of advising clients on a day-to-day. So, I think this type of half-year and year-end review is critical from that perspective as well. That we sort of reflect on what's been happening, so that we can also look at towards the future in terms of what might happen in the market. So I think that's been a good part from my perspective about this series.
Thank you, Timothy. Hoong, over to you.
Yeah, thank you. So for me, I think that it's a good opportunity to get to know all of you, and that we can bring our presentations about the construction laws in our country to the audience. And I think that it's a good opportunity for us to give. I hope that it will be helpful information for the audience. And I believe that we will have more series in the future, so that we can give more information to our client.
Thank you.
Thank you.
Vanak, over to you.
Yes, I think the same old thing with the others, our colleagues in other jurisdictions. It's been a pleasure an opportunity for us to join these webinars. And somehow for us in Cambodia, I feel a bit surprised, because you see, when we were discussing on the development of, especially you see, our construction law was only enacted in 2019. And then followed by the certifying in 2020, sorry. So then it kind of gives me a sense of how far we were behind from the other jurisdiction. So it's a code learning process for us as well. So by then we can advise more on how, I mean, we can advise, of course, to the clients and to the government on how the new law, on how the new regulation should be main priority to be new enacted to safeguard the sustainability of the construction project in Cambodia. And this is a good learning for us, and good sharing with the other offices as well. And I hope we can actually, after this, we can actually have something published or share as a thought leadership, so then we can share across to our client as well, not just by these recordings, as just like as publication, so that we can share to the client that we have a strong teams in Vietnam, in Singapore, in Indonesia, and as well as other jurisdictions. So hopefully we can have something similar to these webinars, a series of webinars across other jurisdictions, so we can cover more areas as well.
Thank you. Vishal.
Thank you. I think everyone has already covered many things, and I'm just glad that we could learn from the construction law and infrastructure law from across jurisdictions, and also able to share the update on each jurisdictions to our client. And that's all for me. Okay,
Thank you. Shafiq.
Thanks, Daniel. Yeah, I also echo all the comments that have been made regarding this matter. I think for me, I feel the biggest takeaway is learning about the different the laws from hearing commentary on the laws of the different jurisdiction in the region. But also, I also personally believe that this webinar series, I think, has potential to be expanded to other areas of laws, to sort of like display that we as an ASEAN Plus group has a really strong group of lawyers working that can work together.
Yep. Thanks, Shafiq. So me, I as a moderator, maybe last word is this. It's actually absolutely exhilarating to find out that something Jason said, actually, it's common sense. We find that a lot of the countries and the laws are all based on some form of common sense, and it all seemed to sync in line. So, if we had come into this project thinking that, we are so far apart and we are all in so many different jurisdictions, and it'll be difficult for us to manage clients and projects, I think we're we have a change of heart now, and we know that if we have clients and people who are interested in or have work in the region, we will have no problems going in there and facing our clients confidently and saying that we can take you there. We can give you preliminary pointers. Our people on the ground in each of those countries can then also expand on it, right? And all of that. So that confidence, I think, is incredible. The second point is about expanding and where we can take this. All of us are in sync with the idea of whether or not we have an annual case law update, a shorter version of this. We will take this offline and we will discuss all of that. But coming up with a year-end or regional aspects of construction law and construction industry is going to be really quite helpful for the ASEAN Plus group. So with that, I'd like to thank everybody and those who have joined us in this. I know we have taken 20 minutes extra today, but thank you so much. But this is not the end of this series, and we hope that this series will develop into the arbitration and into mergers and acquisitions and capital market and everywhere else. So thank you so much for joining us. Thank you.